Hi, my name is Mark Biernath. I'm an estate planning attorney here in the Atlanta area. In this section, we're now going to shift our focus and focus on guardianship in Georgia. We're going to look at what it entails and what are some of the requirements and issues involved in seeking guardianship or conservatorship here in Georgia. Now the state, like the state has a plan for your estate upon death, the state also has a plan for your incapacity. The state will treat different situations differently. Emergency situations have a specific section of the law. There's a doctrine called implied consent, where if you are dragged into the hospital unconscious from a car wreck or something, the doctors are allowed to assume that you want them to keep you alive. That's just implied in our law. Then there's also a situation for involuntary committal, often called a 1013 admission. This is a mental health admission where usually a police officer brings an individual into a crisis health center, crisis mental health center, and a doctor has to determine whether this individual is a danger to themselves or to others. And if the doctor determines that they're a danger to themselves or others, they may be held for up to 72 hours. Those are emergency situations where decision making is, established by law and how it can be done. Now, on that 1013 admission, at 72 hours, if they want to hold an individual longer, there has to be a hearing held. And I know in DeKalb County, where I do most of my work, Judge Rosh actually goes to Georgia Regional and holds the hearings there at the hospital. I don't know how other judges do it. It seems like it'd be very complicated to actually bring that individual to the courthouse, hold the hearing there, and then send them back wherever it is they came from. So I'm assuming that many of the judges will actually go either to the hospital or wherever the facility is that they're being held to do that. Then we're getting to an area where y'all might be more interested. Just out of curiosity, how many of your children who have special needs approaching the age of 18 or over the age of 18? Okay. How many of you already have guardianship? Okay. Those of you who've gone through the process, feel free to chime in. Each court handles things a little differently, but the adult guardianship and conservatorship process is the state's plan for your incapacity. And here we have an emergency guardianship, an emergency conservatorship, and then the non-emergency procedures. Emergency follows the exact same procedures as the non-emergency, but the calendar, the timeline is accelerated. Usually the hearing is held within, I believe it's 5 days of filing. It might be 7 days now. That's one of the things that was changed. But the duration of an emergency guardianship or conservatorship is limited. It's limited to, I believe, 14 days. And during that time, they expect you to file a permanent petition. And you have to pay all the fees all over again. We used to have this great process where we could do emergency and non-emergency all on the same petition. Trouble was, most people would wait for an emergency to arise and then run to court and file the petition and then eventually become the permanent guardianship as well. I guess the state legislature, I don't know if the judges requested this or how it came about, but under the new code, that option is no longer available. It's now 2 separate processes, which in effect will double your cost if you have an emergency situation come up. And one, just so you have an example of an emergency situation to think about, I had a case where mom was driving, daughter was sitting next to her, daughter has Down syndrome. They were in an accident and the mother was liable for the accident. Mother was not guardian of her daughter yet. Daughter gets taken to the hospital because she did sustain injuries, and the doctors would not talk to mom at all. In fact, she was removed from the hospital. Then mother learned that she did not have the authority to make decisions for her daughter. So she went to court to be named her daughter's guardian. Well, in that time, there was this car accident. Mom was liable. Mom was charged with the car accident. And so that presents a conflict of interest because daughter was going to have to sue mother in order to get mother's insurance to pay for the injuries and pay the bills at the hospital. And mom was fine with that because that was how daughter's bills were going to get paid. But that's a conflict of interest. When you have that kind of a conflict of interest, mother cannot be the guardian. And so someone else had to be named daughter's guardian. That is one of the dangers of waiting, because it may be a situation where by law you cannot be the guardian because of something that happened. But the two processes, you got the emergency, which has the accelerated timeline. Usually we can get the entire emergency guardianship done within about 10 days. Non-emergency, we're looking usually about 3 months in the metro area courts. I don't know how long it would take here. Those of you, did y'all file those here in this county? Do you know about how long from the time you actually file? A year. Wow.
We have court twice a year.
Okay. Wow, okay. That any interested person can apply to the probate court for guardianship or conservatorship. So you don't even have to have a family relation to the individual to be named their guardian. You just have to be an interested person. What is an interested person? Just about anybody. The court's going to appoint an attorney to represent the proposed ward. The proposed ward is the person who someone has petitioned to say this person's incapacitated. That's called the proposed ward. And once they are declared incapacitated, then they're called the ward. An independent evaluation will be conducted. This can be done by a medical doctor, a psychologist, a psychiatrist, or now under the new code, a social worker. This is a court-appointed person. You don't get to choose this person unless you are in, I believe it's Forsyth County. Forsyth County, you have to find the person who's going to do the evaluation before you file. Kind of defeats the whole purpose of the court having an independent person, but that's how they do it. So what I suggest to everybody is always call the court clerk before you file your petition to find out if they have any quirky little rules like that. The court does look at any advanced nominations, so in a will or a power of attorney, they will look at that, but again, it's only a suggestion. The court is the one who makes the determination as to who is a suitable guardian.
Now this is just a brief overview of what the guardianship process entails. In the next section, we're going to talk about who the different individuals are that are involved in a guardianship. So please join us.